because that was taken into consideration at the time he was arraigned. Because you want to argue.
I wasn't.
And I'm trying to get information.
I wasn't at the arraignment. I couldn't answer.
I'm trying to get information.
How could I possibly answer if I wasn't at the arraignment?
No, you,
court wants to be
ma'am, are you've been here the whole time. I'm not talking to you because you want to create an issue.
I don't want
and it can go there if you want to. Talk over me again. Talk over me again. Go ahead. Okay. Go ahead. You want to run this?
Be on the record in the matter of Davion Simpson 26-01441. Please.
Good morning, Your Honor. Natalie Maycomber on behalf, or good afternoon, Natalie Maycomber on behalf of the people.
Good morning, Your Honor. Ronald Berry, appearing on behalf of Davion Simpson, was standing to my right.
Okay, this is a. Sorry? Thank you. This is a preliminary examination today for armed robbery carjacking. Are we ready to proceed?
Yes, Your Honor. I understand that both parties will be unconditionally waiving the right to hold a preliminary examination in this matter. We ask that case be bound over on the charges and complaints. There isn't a potential resolution that the parties would like to state on the record for the court.
Yes.
The negotiations that are happening right now is a potential plea to an added count 3 of accessory after the fact. It should be noted that the defendant currently appears to be eligible for HIDA. There would be no objection to that if he was eligible. The parties are still negotiating that ultimate plea and sentence agreement, which would include the dismissal of counts 1 and 2.
Mr. Berry.
That is completely accurate. That's part of the exchange from the examination, and that we have circuit court should we come to a final agreement. And additionally, we have an agreement regarding bond as well, which I'm sure Ms. Smith understands too.
Yeah.
Never put to you, so we just control there. Yeah.
That's really so just.
Okay, so Mr. Simpson, you understand that you are being charged with felonies in this file, correct?
Yes, ma'am.
And you understand that you have the right in this felony matter to proceed to preliminary examination?
Yes, ma'am.
And the right to require the prosecution establish sufficient probable cause the felony you're being charged with was committed, and then sufficient probable cause to charge you as the person who committed the felony. You understand that?
Yes, ma'am.
Are you willing to unconditionally waive your exam?
Yes, ma'am.
That means you would waive it and there's no promises or conditions that you're waiving it on. Once you waive it too, it's gone. You can't change your mind. You understand that?
Yes, ma'am.
Okay. No one's threatening you to get you to waive your exam, correct?
No, ma'am.
There's not been any promises stated, that's not been stated on the record to get you to waive your exam.
No, Your Honor.
The bind over date is July 29th. That's the date the circuit court is receiving this file. It is not a court date for you, Mr. Simpson, okay?
Yes, ma'am.
The next court date for you will be a pre-trial. It will be set after the 29th, and your attorney will be made aware of that.
Yes, ma'am.
You have any questions so far?
No, ma'am.
He has no prior criminal history, correct?
That is correct.
You want to address bond?
We have an agreement, so I guess I.
There's no such thing as an agreement about
Well,
bond.
We have an agreed position to recommend to the court.
You want to address bond?
I believe it's, I would say people have no objection if the court were to reduce this to a PR bond as long as the GPS tether were remain in place. I understand the court has probable cause affidavit in a file, but just as a brief overview, this defendant is a co-defendant in a 3 co-defendant case in which this defendant was charged under the aiding and abetting theory as opposed to a principal actor. Well, I understand that legally those are the same. I think it's important for the court to note when we're talking about bonds that that's how he was charged under that theory. However, obviously, the court is also aware there was a very high likelihood of this potential resolution to be both life offenses being pled down to a 5-year accessory after the fact under the HYTA status. My understanding that the defendant's family is to report with him today. They were in court with him last time. And speaking of Mr. Berry, the defendant has a stable home to go home to. So we would just be asking for GPS tether when it's in the vacation. Mr. Berry?
I agree with all that and further echo that his mother is here. She's in the courtroom today under bond package to be considered, whether as a member of the community can vouch for him and be responsible.
Can you speak up a little bit because it's the band.
Thank you, Your Honor. Under the court rules, as far as having someone of the member of the community that can vouch for him and be responsible for him, she is willing and able to do that. She has indicated to me that he would be living in her home She's going to make a run. Sure, she runs tight ship. He follows, any rules and conditions set forth by this court. Both spoke with him as well as his mother about one of the important, well, I guess all conditions are important, but one of the conditions is not to talk with any of the co-defendants or any other restricted parties or the alleged victim in this matter. And he indicates to me that he understands that completely. He has absolutely no intention, desire to do so. He's committed to following the conditions. The court can put, like do a tether or a curfew, can do that as well. He understands right now he's not accepted any kind of plea agreement, nor is there one that's going to be required to be given to him, especially if there's any kind of violations between now and this next court date. He understands that, and he's not trying to mess anything up yet.
Was he living with his mom at the time of the alleged incident?
I was living with my mom, but I was.
That's what it said in the pre-trial services report. So that does make me feel like something changed.
I understand, Your Honor, but you're taking, that doesn't.
You use that as your argument.
Sure.
I didn't. You said that he's going to live with his mom. She's going to run a tight ship. Wasn't he living with his mom before then?
Well, I don't know if the court. Hopefully, the court's not assuming guilt. But beyond that,
I'm just repeating back what you said.
Well, I know, but you're doing it with the presumption that the implicit that if he's charged with this act, that somehow she didn't run a tight ship.
If I may.
I'm trying to get away from that. My point is, if you do a curfew,
you can go back and forth with me with this if you want to. I'm repeating your statement, and that is that he lived with his mom, and if he's released, he's going to live with his mom, and if he's released with his mom, then she's going to run a tight ship. My question was, wasn't he living with his mom before then? And you're the one who got defensive because you could have said whatever you wanted to say. I didn't.
The court did have a follow-up question.
Yeah, I said what? I said, how is that a difference? What has changed?
And I was trying to explain.
Explain it without being argumentative.
Well, then my response to the court then, why would it need to be any different? Is the court
because you're telling me that one of the things I need to consider is that he's going to be released to a member of the community that can help supervise. I'm trying to understand how is that different from what happened at the time that he was arraigned?
Why would it need to be different?
Because that was taken into consideration at the time he was arraigned.
I may, Your Honor.
No.
Yes, it was. It's in the bond recommendation.
I don't know that this court.
Yeah, I'm done talking to you.
If I may, in reviewing, and obviously I understand this is the defense, but in reviewing the interviews with the defendant, the co-defendants, the witnesses, and this is my understanding, so please correct me if I'm wrong, Mr. Berry or Mr. Simpson, but while Mr. Simpson's address and residence was with his mother, he wasn't necessarily staying there.
That's my question.
Now,
this said he was. I'm looking at what the magistrate considered at the time. I'm asking you, what is the difference that you want me to now consider outside of the offer and what she said? I'm not looking for you to try to decide what I'm thinking.
Well,
you don't know what I'm thinking. I don't know anything about the facts. So how could I think anything?
Well, then how can this court put me? I asked
the question.
May I respond?
No, because I already told you I was done talking to you because you're argumentative. So I'll ask your client. Was you living with your mom before this?
I wasn't. That was the address.
You can tell me and I can respond.
No, I'm asking your client.
I'm going to direct him not to respond to
Oh, okay. Well, then I don't have anything to consider then. Because you want to argue.
I wasn't.
But I'm trying to get information.
I wasn't at the arraignment. I couldn't answer.
I'm trying to get information.
How could I possibly answer if I wasn't at the arraignment?
No, you wanted to assume that I'm taking a position when I'm trying to get information.
The court wants to be.
Ma'am, you've been here the whole time. I'm not talking to you because you want to create an issue.
I don't.
And it can go there if you want to.
I don't know where it's supposed to go.
It's supposed to be that you answer the questions without saying, "Well, I hope the judge." You don't know what the current. I don't know anything about the facts. How would I know anything? I haven't even read. Talk over me again. Talk over me again. Go ahead. Okay. Go ahead. You want to run this, or you want to answer my question?
I can't make this court happy, so I'm going to.
No, you can. You could.
I've tried.
I've seen you do this in multiple courts. Do you know that? I've seen you do it to multiple prosecutors, and I've seen you do it on multiple records.
So the court is mad.
I'm not finished. I'm not mad at anybody, but I'm not going to allow you to be argumentative or overtalk me. I asked a simple question, and I wanted a simple, direct answer. How is this different from what was provided before at the time of arraignment? A simple answer could have been what he was suggesting. Well, I wasn't really staying with my mom before. But that's not what you said. Ma'am, what's your name?
Machine Smith,
You're his mother. Okay, what's your address?
1610 Chestnut.
1610 North Chestnut.
Yes, ma'am.
Is your son employed? He was at the time of arraignment.
Yeah, he had just got the job off.
Okay, so he doesn't have that job. You're still 19, correct?
Yes, Your Honor.
Bond is set at 75,000 personal recognizances with GPS tether and victim notification if possible. You also will have a curfew between 6 p.m. and 7 a.m. unless there's evidence that you are employed during those timeframes, okay?
Yes, Your Honor.
You will be residing at 1610 North Chestnut with your mother. I have a phone number ending in 6175. Is that accurate?
Yes, Your Honor.
Any additional matters for the record?
Yeah, if I just make sure, just because I have the register of actions printed out, it has 1016 North Chestnut.
Yes, but he might have given the wrong address.
Okay.
That's what we had to, or the magistrate could have wrote it wrong.
Sure.
Any additional matters for the record?
No, Your Honor, thank you.
No,
The magistrate didn't write it wrong. That's on the pretrial release too. You're all set.
bye.
Not the wrong one. You said what? He's always too much. They didn't say one who got in a fight with Nagel?